Honorable Justice Sanjeev Khanna, Judge, Supreme Court of India. Honorable Justice B.R. Gavai, Judge, Supreme Court of India. Shri Arjun Ram Meghwal, Minister of State for Law and Justice. Shri R. Venkat Ramani, Learned Attorney General for India. Shri Kapil Sibal, President, Supreme Court Bar Association. And Shri Manan Kumar Mishra, Chairman, Bar Council of India. On this landmark day, as we convene in the spirit of collaboration, reflection, and progressive dialogue, I humbly request Honorable Justice Sanjeev Khanna, Judge, Supreme Court of India, to kindly deliver the welcome address.
Namaste, and a good morning to everyone. It is a great honor and privilege that I extend warm welcome to all of you at this National Conference of the District Judiciary. Today we are witnessing a historic congregation of approximately 800 judicial officers from across the country, a truly remarkable gathering that embodies the spirit of the judiciary. We are deeply honored by the presence of the Prime Minister of India, Shri Narendra Modi ji. He has consistently expressed his regard for the judiciary and has presented his vision for its evolution, a vision that emphasizes in simplicity in both the legislation and judgment writing, making them less technical, less legalistic, and more citizen-friendly. He has been an advocate for embedding Indian ethos into our laws, a thought we should be mindful of. He is dedicated to enhancing the ease of living, the ease of doing business, encouraging dispute resolution, and minimizing litigation. His perspectives and insights will serve as words of wisdom to us as we continue in our efforts to serve the common man better. We are guided in this pursuit by Dr. Justice D.Y. Chandrachud, the Chief Justice of India. His technological acumen has brought about path-breaking changes. His commitment to the cause of justice and tireless efforts have brought about district judiciary to the forefront. This is the second time a conference of this stature is being hosted. The first being the All India District Judges Conference in Kutch, Gujarat, held earlier this year. Our Chief Justice played a stellar role in organizing both these conferences, which has provided us invaluable opportunity to hear directly from the judicial officers about the challenges and issues facing the district judiciary and how we can work together to improve it. We are also privileged to have amongst us Shri Arjun Ram Meghwal, the Minister of State for Law and Justice. Being down-to-earth, receptive, and open to all perspectives are his great strengths. Mr. Meghwal has balanced approach. While he fosters coherence, he accepts judicial independence. We are equally fortunate to have with us Mr. R. Venkat Ramani, the Attorney General of India, a learned jurist with a poetic bent of mind. Mr. R. Venkat Ramani is unfailingly fair in his approach. He embodies a unique blend of composure and assertiveness in the courtrooms. His demeanor is nothing short of exemplary and harks back to the old times. Mr. Manan Kumar Mishra, Chairman of the Bar Council of India, has deep connections with the grassroots and district judiciary in our country, giving his thoughts a unique perspective. He represents aspiration and voice of over 15 lakh advocates. Mr. Kapil Sibal, the President of the Supreme Court Bar Association, is an advocate with formidable oratory skills. No surprise given his involvement in theatre. He has donned many hats as a bureaucrat, as a member of parliament, and as a minister. Outspoken, insightful, and learned, he brings a wealth of experience that is invaluable for us. My esteemed sister and brother judges, it fills me with immense pride and deep respect to welcome you all today. I began my career in the hallowed halls of the district courts, observing, learning, and guided by judges and lawyers. I owe a debt of gratitude to the district judiciary. In the expanse of the judicial hierarchy, the district judiciary often finds itself overshadowed by the high courts and the Supreme Court, receiving less limelight and coverage. To put things in perspective, in the calendar year 2023, our district courts handled more than 10 times more cases than the high courts. Therefore, it is said, and I quote, if an evaluation were to be made of the importance of the role of different functionaries who play their part in the administration of justice, the top position would necessarily have to be assigned to the district court judge. It is mostly the district court judge rather than the appellate judge that the members of the general public come in contact, whether as parties or as witnesses. And thus the image of the judiciary for the common man is projected by our district court judges. Today, the entire judiciary is faced with the problem of pendency and backlog of cases. Thus, efficient functioning of the district judiciary is crucial to mitigating these challenges. To look at a brighter side, the data reveals that disposal rates in the district courts have gone up considerably since 2018. In 2018, the percentage of civil cases disposed of, including previously pending cases, compared to the freshly instituted cases, stood at 93.15%. Remarkably, in 2023, the disposal rate of civil cases shot up to 99.61%. In 2018, the rate of disposal of criminal cases stood at 86.65%. In 2023, the rate increased to 95%. A closer look at the data from 2023 reveals the following interesting data points. Majority of the civil cases, amounting to 38.24%, were disposed of within a year of being instituted. 71.82% of the criminal cases were disposed of in 1 year. Approximately 11 states successfully reduced the case backlogs by disposing of more cases than were instituted in the year. Thus, in these 11 states, cleared a proportion of the backlog cases compounded over the previous years. We have taken a number of steps to reduce pendency, including taking help of lok adalats as far as traffic challans is concerned, creation of e-courts to deal with lok adalats as well as petty offenses. Judicial impact assessment, a much-discussed strategy for case management at all tiers of the judiciary, can be a powerful tool in assessment and enhancing the human resource and infrastructure in judiciary. This assessment has legislative and executive connotations as well. Truly interacting with the data represents, we can know our successes and weak points. Ultimately, it is not the grandeur of the courtrooms or the sophistication of our technology that will define us. Rather, we will be defined by our unwavering commitment to delivering justice, by enhancing access to justice, serving the people with compassion, empathy, and fairness. Thank you, and Jai Hind.
Thank you so much, sir, for your profound words of wisdom, which have truly set the perfect tone for deliberations ahead. I would now like to request Shri Kapil Sibbal, President, Supreme Court Bar Association, to address this distinguished gathering.
Honorable Prime Minister of India, I may take the liberty to call you Narendra Bhaiji. Distinguished dignitaries present here, I feel honored and privileged to be present here at the National Conference of the District Judiciary to mark the 75th year of the establishment of the Supreme Court of India. Any structure with a weak foundation will impact the edifice and eventually collapse. The justice delivery system at the foundation of the judicial structure needs to be strengthened both in terms of quantity and quality of manpower and infrastructure. Our trial court and district and session courts need to be empowered to deliver justice without fear and favor, unless people at the bottom of the pyramid have the ability to withstand the pressure the superstructure of the polity will not be able to deliver. I don't want to call the judiciary at the level of the trial court and district and session judges to be subordinate, because the judge sitting there delivers justice, and the question of being considered as subordinate to any authority is a contradiction in terms. The judiciary at that level should be instilled with the confidence that their judicial pronouncements shall never be held against them, and that they represent the spinal cord of the justice delivery system. They should have the flexibility and the independence to render judgments in accordance with law without fear or favor. The effectiveness, fairness, and integrity of the courts impacts the perception of the public on the credibility of the entire judicial system. The fact that the trial court and district and session courts are loath to grant bail in matters of some significance itself is symptomatic of the malaise that has set in. In the course of my career, I have seldom witnessed the grant of bail at that level. This is not just my experience, but the Chief Justice of India has said often enough that court at the highest level is burdened with matters of bail, because at the level of trial courts and district and session courts, bail seems to be an exception. Of course, it goes without saying that the grant of bail depends on the facts and circumstances of each case, but the pronouncements of the court have in the recent past adhered to the principle that bail is the rule and jail an exception. We've seen trends harking back to the law laid down in Gurbakh Singh Sibia, wherein this principle has been enunciated and has now been reiterated by the Supreme Court of India in several recent judgments, even in relation to special acts which require stringent twin conditions. Liberty is the foundational substratum of a thriving democracy. Any attempt to throttle it impacts the quality of our democracy. Moving away from liberty, we need to address the problems being faced by trial courts and the district and sessions courts, which impede the quality of the justice delivery system. The judge population ratio in India is abysmally low, 21 judges to a million population, as compared to over 100, and in Europe, over 200 judges to a million population. Therefore, the roster at the level of the trial and district and session courts is overburdened on a daily basis, which impacts not just the justice delivery system, but lives of millions who are waiting for justice to be delivered. They come to court day in and day out for their matters to be heard expeditiously and fairly. However, in the absence of quick disposals, they have to wait for years, which impacts them both economically and mentally. The court cannot even imagine the mental agony and the economic consequences of these kind of delays. Furthermore, our young, talented people choose not to seek appointments at the trial and district sessions courts due to abysmal conditions in which judges operate. Despite this, many of the judges, through sheer hard work and commitment to the cause, are doing yeoman service to the nation, even though they are handicapped by lack of proper courtrooms and office facilities, supporting staff, including stenographers, library facilities at home, appropriate residential accommodation, and necessary transportation facilities. Needless to mention the meager salary that those serving the cause of the nation draw to discharge their duties. Unless we are able to improve their conditions of work, both in terms of salary and infrastructure, the quantity and quality of the justice delivery system will suffer. Some of the problems that need to be addressed are the following, and I will not elaborate on them. Pension. Despite the fact that the Supreme Court had accepted recommendations of the Shetty Commission and subsequently the Padmanabhan Committee, the NPS was made applicable to judges of district courts from 2005 without even consulting the high courts. The major disadvantage of NPS that the monthly annuity provided to judicial officers after retirement is much less than the pension that a judicial officer having the same length of service and having retired from the same rank receives. Under the NPS, the retired judge gets a monthly annuity, in some cases to as low as $13,965, as against $1,63,000 under the old pension scheme. Promotions. The promotional avenues are limited for judges who join as civil judges in the district judiciary. Some judges join as civil judge and retire as civil judge. While the Shetty Commission had highlighted the problem and suggested a weighted system, but it was rejected by the Supreme Court on ground that the introduction of a roster system would resolve the issue. It hasn't done so. Gender sensitization. Nationally, the share of women in the district judiciary has crossed 33%. However, a conducive work environment to welcome women judges is missing due to a lack of residential accommodations, separate washrooms in courtroom premises, creches, and security. Technology. Most of the judges of the district judiciary are not well equipped with technology for the purposes of research, conducting trials. While the libraries is diminishing from residential offices, judges are not properly trained to avail e-library and e-journal facilities, and in some cases, they're not even available. Incentives to join judicial services. Young and bright students from national law schools seldom join judicial services, and they do not see promotional avenues and lucrative monetary benefits. I urge everyone on the dais to urgently address the persistent issues being faced by judges of the trial and district and session courts, who are the backbone of our judicial system. It is time for us to make our justice delivery system more efficient, stronger, and viable. I echo the words of Andrew Jackson, who is often praised as an advocate for ordinary citizens, and I quote, "All the rights secured to the citizens under the Constitution are worth nothing in a mere bubble, except guaranteed to them by an independent and virtuous judiciary." Thank you very much.
Thank you, sir. Your address today brought a wealth of knowledge and experience that will undoubtedly inspire and inform all judicial officers attending this conference. May I now request Sri Manan Kumar Mishra, Chairman Bar Council of India, to address this august gathering.
Honorable the Prime Minister of India, Sri Narendra Modi ji, Honorable the Chief Justice of India, Dr. D.Y. Chanchud, the dignitaries on the dais and off the dais. In my opinion, even after whatever shortcomings were pointed out by Mr. Kapil Sibal ji, judicial services are supposed to be the best and most prestigious today in comparison to all other services. The role of judges is one of the unparalleled gravity and immense responsibility. Our judiciary, the pillar of our constitution, embodies the very essence of justice in our democracy. It commands the deepest respect and trust from the citizen. Under the visionary leadership of Dr. Chanchud, the Indian judiciary has not only upheld this trust, but has also set a global benchmark, and the role of Indian judiciary as a torchbearer of justice is now recognized by the entire world. Sir, our vast nation with its rich diversity of languages, religions, and intricate legal frameworks renders the work of our judiciary particularly demanding. The complexity and sheer volumes of cases that our judges at all levels navigate are staggering. However, the efforts of our Modi ji's government in simplifying the legal landscape, repealing obsolete statutes, is laudable. Sir, recent introduction of Lok Adalats by Supreme Court under the leadership of Dr. D.Y. Chanchud marks a significant milestone in judiciary's efforts to make justice more accessible and expeditious. The Chief Justice of India has taken historic and bold steps to strengthen the district and taluka judiciary also. This conference would prove a milestone in making the district judges emboldened in discharge of their functions. Sir, the role of Prime Minister as the leader of the world's largest democracy is one of the immense responsibility and unparalleled significance. Our Narendra Modi ji also navigates a complex landscape where national security is constantly under threat, requiring decisions that are both prudent and decisive. Ensuring the protection and safety of every citizen, regardless of religion or caste, is not a joke. It's a constitutional duty that demands unyielding and persistent, honest and sincere vigilance. And that is the reason today our Modi ji is the world's best Prime Minister and best diplomat. It may be Ukraine or Russia or any other country in trouble, they require the support of our Modi ji. Sir, you are an ideal. Your distinguished tenure of 15 years as Chief Minister of Gujarat, followed by over a decade of leadership as Prime Minister of India, stands as a remarkable reflection of a career marked by integrity and dedication. Such an exemplary and unblemished journey in public service serves as an inspiration to leaders and politicians worldwide. Really, sir, you are the great. Sir, the recent continuous unfortunate events in West Bengal, particularly the tragic rape and murder of a young lady doctor in West Bengal, have starkly illuminated the indispensable role of Supreme Court in safeguarding justice. The suo motu intervention of Honorable Chief Justice of India and Supreme Court in this case serves as a powerful reminder of the duty of judiciary to uphold the law and ensure accountability of a state's deliberate failure to handle the situation. It is our solemn duty to protect and uphold the Constitution. This revered document must not be exploited and for political gains, misleading the ignorant or the illiterate for electoral advantages poses a serious threat to the nation's stability. हमारे संविधान का माखौल न उड़े, इसको मजाक ना बनाया जाए। देश का संविधान, आरक्षण या लोकतंत्र को कोई खतरा नहीं है। आप सभी बुद्धिजीवी बखूबी जानते हैं, देश को यदि सही मायने में खतरा है तो इन बेबुनियाद बयानबाजी से जो सीधी सादी भोली भाली अनभिज्ञ जनता को बरगलाने का प्रयास करती है। Constitution is safe, reservation is safe at the hands of our Honorable Prime Minister and Honorable Chief Justice of India. Under the guise of human rights, no one should be permitted to compromise the sovereignty and security of our nation. The number of enemies within our country is swelling day by day, outnumbering even external ones. In conclusion, I must say, 25 lakh lawyers stand resolute as the defenders of our judiciary, its judges, as well as the government in its effort to combat enemies of the state and anti-social elements. I conclude by saying that the members of the legal and judicial framework and guardians of the Constitution, it is our solemn duty to uphold the principles enshrined in our Constitution. The judiciary and the executive must work in unison to protect the nation from both internal and external threats, ensuring that the Constitution is not misused for personal or political gains. Lawyers and judges are to remain vigilant and proactive, safeguarding the integrity of our nation and ensuring that justice prevails in every corner of country. I wish the conference a grand success. Jai Bharat Mata, Jai Bharat ka Samvidhan.
Thank you, sir. Moving ahead, I would now like to request Shri R. Venkatramani, Learned Attorney General for India, to say a few words on this landmark occasion. Kindly guide us with your words, sir.
Honorable the Prime Minister, distinguished dignitaries of the dais, distinguished invitees. You're part of a unique conference, unique in several senses. This is the first time, perhaps, after independence, all of us are assembling at the national level in the national capital to share our insights, experiences, and concerns relating to the district judiciary. This is also the first time that we assembled to remind ourselves that what concerns the district judiciary concerns the entire administration of justice at the national level. This is further unique because this conference will set in motion, institutionalizing the periodic stock-taking of the internet connectedness of administration of justice. This is also unique in the sense that the Supreme Court of India organized this conference inviting the entire legal fraternity to focus on the concerns which confront the entire district judiciary. I must hugely appreciate the ever-energetic Chief Justice of India and his companion justices for conceiving this conference. It is indeed very significant that the Honorable Prime Minister of India is with us today. That a Prime Minister who always intently listens is with us means that he is keen to underscore the importance of this conference. I mean to say that when the Honorable Prime Minister listens, he acts and executes what is just and for common good. The conference subjects have been chosen carefully, and all of them are so connected, and I will be too glad to be any part of any task to be undertaken. Just as the nation is moving into momentous stages of integrated social and economic development in the midst of visible and invisible challenges, global and domestic, and development informed by equity and equal regard, social partnership in new forms of knowledge and wealth creation, courts are called upon to be partners in these national transformation programs. A good governance takes all suffering seriously, and courts are meant to take suffering seriously. The district judiciary takes the bulk and mass of justice demands and causes of we the people of India. It's called upon to be closer to the people in its task of doing justice. Taking suffering seriously and doing justice relevantly are so connected that the underlying tasks and agendas have to be drawn nationally. Administration of justice, if to remain in aid of citizens' pursuit of solace and comfort, ease and enablement, these agendas are important. How do we make and shape our court systems place of solace and comfort instead of being burdensome and uninviting? How do we ensure that the court environments are as good as the environments of leisure as would immensely contribute to the efficiency quotient of doing justice? How do we guarantee to the judges' work and service provisions that will incentivize honest and committed involvement? How do we creatively and innovatively develop emerging technologies as tools of doing justice? In a fundamental sense, how do we ensure that the district judiciary is enabled to bear its burdens with manifold support and assistance that they cease to be burdensome? Debates on these questions are timely. Unless the district judiciary is poised as good and important as the higher judiciary, national commitment to justice will be incomplete. Technology has come as a great boon to take care of doing away with current time-consuming and dispensable physical distances involving exercises. Probably, we need a national district judiciary capacity building commission. I say so because for long, Supreme Court has been involved in addressing the concerns of district judiciary. It is time that it gets institutionalized with the participation of government and the courts. I must also point out that the burgeoning call for rights enforcement and the expansions of rights horizons have ushered in new challenges for courts at all levels. Even if one is critiqued, I wish to say that there cannot be excessive and undue demands which will stress governance and bring fissures. Rhetorics and responsibilities do not go together. The dharma of sharing social costs and social wealth and responsibilities is a misunderstood subject. All of us therefore called upon to to be positive contributors and not armchair critics. We need to be explorers and not shipbreakers. It's important that certain tasks are left to be responsibly taken care of by governance institutions, that they continue to be responsible. And even in a common march, task assignment are important. As I gather from comparative information from other countries, we are doing fairly well with the technology use. If what is being done at Supreme Court and High Courts can be done at the district level, the legal fraternity will become harbingers of new dimensions of doing justice. The call of the conference is a different call on the shoulder of the legal fraternity. I therefore deeply appreciate the very important conference. Thank you for your attention.
Thank you so much, sir, for your thought-provoking and enlightening address. अब मैं विधि एवं न्याय मंत्री श्री अर्जुन राम मेघवाल जी से विनम्रतापूर्वक आग्रह करती हूं कि वो इस सभागार में उपस्थित सभी श्रोतागण को संबोधित कर हमें अनुग्रहित करें।
नेशनल कॉन्फ्रेंस ऑफ द डिस्ट्रिक्ट जुडिशरी, इस अवसर पर माननीय उच्चतम न्यायालय अपनी स्थापना के 75 वर्ष मना रहा है और देश संविधान के लागू होने के 75 वर्ष मना रहा है। ये बहुत ही एक सुखद संयोग है। इसी अवसर पर आयोजित नेशनल कॉन्फ्रेंस ऑफ द जुडिशरी के भव्य समारोह में उपस्थित विकसित भारत के संकल्प को सिद्धि में परिणत करने हेतु प्रतिबद्ध विश्व के लोकप्रिय नेता, युग नायक, भारत के यशस्वी और तपस्वी प्रधानमंत्री नरेंद्र मोदी जी, न्यायिक व्यवस्थाओं में इनोवेशन के लिए पहचान बनाने वाले डॉक्टर जस्टिस